Are you being bombarded by advertisements from so-called debt consolidation companies alleging that they can help you? While most of these advertisements sound promising on the surface, and some companies do indeed provide a valuable service, did you know that many debt consolidation companies are actually telling you indirectly to intentionally damage your credit? They represent that they will begin to contact your creditors immediately and begin to work out payment arrangements. But in actuality, you are still being done by your creditors and collection agents and remain at risk of having litigation commenced against you and the possibility of the enforcement of judgments that have been already entered against you. Many creditors will not work out repayment arrangements with consumers who pay on time. Most of these debt consolidation companies will tell you day one to stop paying your credit card debt for at least 60 to 90 days before they will even begin to contact your creditors. Debt consolidation companies are only interested in collecting their fees. Many debt consolidation companies will ask you to immediately begin to remit payments to them, but did you know that none of those payments are actually going to your creditors? Most companies front-end load their fees, meaning that they will collect their fees first, regardless of whether or not they produce any results. In addition, although many companies do not disclose it directly in their advertising, there is no guarantee that your creditors will deal with debt consolidation companies. From the onset, there are numerous creditors that will absolutely not deal with debt consolidation companies. And lastly, debt consolidation companies may not even lower your payments, and in fact, you may be asked to pay a higher amount than you're presently paying in your minimum payments. Using Chapter 13 bankruptcy as a pure debt consolidation tool is fairly straightforward. Chapter 13 bankruptcy can be viewed as personal reorganization. In Chapter 13, the law requires you to deal with all of your debt obligations at once. Bankruptcy is not a pick and choose process. The law requires you to deal with all of your creditors, and your creditors must deal with you. Creditors have no choice when you file a Chapter 13 bankruptcy. They must comply with the requirements of the law. In Chapter 13, your repayment plan is not based upon what the creditors want or may be willing to accept. Your monthly payment shall be based on what your individual circumstances shall allow you to safely pay within the guidelines set down in the federal bankruptcy law. This amount is determined by the means test. The means test has been designed to determine what may be a fair and reasonable amount to repay your creditors based upon your income and expense, as well as where you reside. In Chapter 13 bankruptcy, you are in control of your financial situation. The filing of a Chapter 13 bankruptcy case is purely voluntary. You are actually proposing your own repayment terms within the guidelines set down in the bankruptcy law. So long as your plan of repayment proposes to pay that amount that is set down in a means test, your creditors have no choice, and they must accept the repayment terms you have proposed.